You thinking about selling your home in California? What you don't tell a buyer could land you in court. Okay, under California Civil Code 1102 and 1102.19, every seller of a 1 to 4 unit home has a legal duty to disclose known issues that could affect the home's value or desirability. Here's what that means in plain English. So first up, the transfer disclosure statement, or the TDS. You must fill it out truthfully. This is a big one. You must list anything that you know is wrong with the property. So if you know your roof leaks every winter or there's unpermitted work, it has to be disclosed, even if it's been fixed. Second up is the natural hazard disclosure. Required under California Civil Code 1103, you must disclose if your property is in a flood, fire, earthquake fault, or landslide zone. So if your home sits in a SoCal fire designated very high fire hazard severity zone, that must be on the NHD report. Third up, the lead-based paint disclosure law. This is federal law, and the federal law requires this disclosure for homes built before 1978. You have to provide the buyers with the EPA booklet and disclose any known lead paint hazards. Death on a property. You don't need to report every death automatically, but if it's something a reasonable buyer would want to know or it affects the desirability, you must disclose it. In California, it's typically 3 years, but it depends on the scenario. Fifth up, other material facts. Anything else that could influence a buyer's decision. For example, if you have past neighbor disputes, pest infestations, drainage issues, noise problems, foundation cracks, if you know it could affect how a buyer feels about the home, you need to disclose it. If you're not sure whether to disclose something, do it anyway. Over-disclosing protects you. Under-disclosing can cost you a lawsuit and cost you in profit. So if you're buying your own house, would you feel like you know the whole story?